Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148 which gives the importance of reason to believe before issuing the notice under section 148. The name of the case is Avinashilingam Institute for Home, Science and Higher Education for Women versus Assistant Commissioner of Income Tax Exemptions. This case has been reported in 458 ITR at page number 491 and the matter has been decided by Honorable Madras High Court in the writ petition filed by the Assessee. The date of the judgment is 21st February 2023. The crux of the case is that whether the department, solely on the basis that the assessee has fixed deposits of a very large amount, can issue the notice under section 148 without going into the integrities of the facts and circumstances of the case, or without correlating or keeping a nexus, a live link between the information received and the income escaping assessment of the assessee. In the present case, the assessee was claiming exemption under section 1023C clause iiiab. Since several years, the assessee is a Tamil Nadu. The assessee is registered under Tamil Nadu Societies Registration Act 1975. It is a deemed university since decades and it is approved by University Grant Commission. The assessee was having huge infrastructure in the assessee's society. Lakhs of students have passed from there and there were very huge amount of fixed deposit with the assessee. As per section 139 subsection 4C, the assessee was required to file the return of income from the assessment year 16-17. Before that, the assessee was not required to file the return of income. When from the assessment year 16-17, an obligation was casted on the assessee to file the return of income, the assessee started regularly filing the return of income, and assessee was also assessed under section 143 subsection 3 for the assessment year 16-17, 17-18 and 18-19, and the assessing officer accepted that the assessee is a genuine society which is working for the education and accepted that the assessee is entitled to get the exemption under section 1023C clause iiiab. But since the assessee was not required to file the return for the assessment year 15-16, the assessee has not filed the return for that year. So on that basis alone, that the assessee has not filed the return for the assessment year 15-16, and since the assessee has huge fixed deposits, the assessing officer issued notice to the assessee under section 148. The assessee challenged this notice before the Madras High Court that the assessing officer do not have the reason to believe that the income has escaped assessment. The reason for this ground was that the assessee took the ground that since the assessee is a deemed university since decades and it is very much essential and natural to have the crores of rupees of deposits because it is a very old organization and this much of the fixed deposit was required to develop the infrastructure for the university. Then in that case, when the assessee is filing the return for several years since assessment year 16-17 and that it has been accepted by the assessing officer that the assessee is working for the purpose of education and the assessee is entitled to get the exemption under section 1023C clause iiiab. So solely on the basis that the assessee has huge fixed deposits without going into the integrity, that the same fact has been accepted by the department in the coming years, in the subsequent years. So solely on the basis that the assessee has fixed deposits of big amounts, the notice under section 148 cannot be issued without establishing the live link that having these fixed deposits, the assessee's income has escaped assessment. Since the assessing officer do not conduct any inquiry in this case, that the assessee is a regular taxpayer, the assessee is filing return of income very regularly and even deducting the TDS for the various persons, and in the subsequent years the income of the assessee has been accepted, the return of the income of the assessee has been accepted, and it has been accepted by the department that the assessee is a genuine institution which is claiming exemption under section 1023C clause iiiab. So in that case, without establishing the live link between the escaped income and the information in hand with the assessing officer, the notice under section 148 cannot be issued, and hence the Madras High Court quashed the notice in the lack of reason to believe with the assessing officer. Friends, this case is very important because nowadays we see that the notices are coming like nothing without having the reason to believe and without establishing the live link between the information and the income escaping assessment of the assessee. So in that case, that notices can be challenged on that ground itself. At the end of this video, once again I am repeating the name of the case. The name of the case is Avinashilingam Institute for Home Science and Higher Education for Women versus Assistant Commissioner of Income Tax Exemptions. This case has been reported in 458 ITR at page number 491. The matter has been decided by Madras High Court and the date of the judgment is 21st February 2023. Thank you, friends.